Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to this sitting of the Appeals Court. I'm Justice Shin, and with me are Justices Englander and Hand. We're hearing one case by video conference today, and it is Commonwealth versus Joshua Paulo, number 2020 P845. Attorney Lindmark.
Yes, good morning. May it please the court, I'm Attorney Lindmark. I'm here arguing on behalf of Mr. Paulo. The essence of our argument today is that the police had no business being in Mr. Paulo's car when they were. No reports had come back that the car was stolen at the time. And as such, anything seized should have been suppressed. Their actions were unreasonable and not proper procedure. Unfortunately, depending upon which officer was testifying and at which hearing, I believe there were 4 in total, there are various conflicting reports as to how and when the car was first discovered. That they were interested in finding the car became clear. Officer Larkin, in particular, at trial, he said he was told the car was stolen and then called for a tow and began the inventory search of the car. We're alleging the inventory search was not proper.
Why are we looking to what happened at trial?
Excuse me?
Why are we looking to the trial transcript when we're deciding whether the motion judge erred?
I would agree with that it's not totally relevant. It is interesting to see how his testimony did change, however. At the dangerousness hearing, he specifically said that it was only after Mr. Paulo was taken back to the station that it then called in the motor vehicle information and was told that the car was stolen. By that time, of course, the tow, they had already ordered.
The dangerousness hearing precede the hearing before Judge Green on the motion to suppress?
It did, Your Honor. I have a timeline.
There's not a single piece of cross-examination from the dangerousness hearing at the hearing before Judge Green. And she makes specific findings as to what happened. And
she did, Your Honor.
I mean, based, how you essentially are asking us to find that she committed error based on something she knew nothing about.
Well, Your Honor, our suggestion here is I bring up the dangerousness hearing only because that took place 1 year, almost exactly 1 year prior to the motion to suppress hearing. And the main officer who testified at all of these hearings, his testimony then 1 year earlier was quite different from what he eventually testified to at the motion to suppress hearing.
Counsel, as you know, the process to deal with this is called cross-examination. And we're not in a position to know what was right or what was wrong based on you saying, hey, look, he changed his story. Here he said this, here he said that, where none of them were ever confronted to him at the same time.
I understand what you're saying, Judge, and I do tend to agree. However, we're trying to make an overall argument that the eventual inventory search was not proper. There are serious questions as to police intentions, as it appears to have been more of an investigatory search. That's our position. There were no extenuating circumstances which would justify an inventory search here. The car was legally parked on a public street. There were no known public safety issues.
Let's just back up for a second. I want to make sure I understand. So let's assume that we were to take what you describe as the testimony at the dangerousness hearing, that he didn't find out the car was stolen until he got back to the station. Why would an inventory search of the car be improper at that point? The evidence that the judge credited is that they knew which car was his, and Lindmark testified consistently that there really wasn't anything else in the neighborhood except that one car, which wasn't very far away from where he made the arrest. So what would be wrong with an inventory search at that point?
Well, you're suggesting that the inventory search is fine whether or not they had knowledge of whether the car was actually stolen?
No, well, oh, I'm sorry. So you're saying the inventory search occurred before they ever found it was stolen?
Correct. That's our argument here, Judge.
But the judge found otherwise, correct? As far as based on the
Judge at the
evidence that
suppression, yeah. Yes, I'm sorry for interrupting.
No,
Yes,
okay.
Your Honor, she did. She did. And our argument that we're trying to establish is that she was incorrect in making that finding, that in fact, procedurally, the officers did not follow their own written procedure. Technically, what they were supposed to have done was to call in the car information. If it's determined the car was stolen, then perhaps they would have had grounds to conduct an inventory search, which we also suggest went far
But that's
beyond
what she found happened. She found, as a matter of fact, that they knew that the car was stolen before they began the inventory search. So how did she commit error? And she found that based on the testimony, which said that.
Well, Your Honor, my understanding of the standard of review here is the reviewing court accepts a judge's findings of fact absent clear error, and also can conduct an independent review of his or her ultimate findings. And we're suggesting today that you should find that there was clear error here, and that her ultimate findings were not correct.
The testimony at the dangerousness hearing was not before Judge Green, right? And it was not used in the cross-examination at trial, right?
Correct, Your Honor.
So how is it even in the record before us?
I'm not sure if it was included in your record. I do have a copy of the dangerousness hearing transcript in front of me.
Well, you cite it in your brief, don't you?
Yes.
I mean, I'm just trying, I'm sorry that I'm
No,
running a little behind here, but
Your Honor, some of these cases are much more clear-cut, shall we say, than others, and this is somewhat of a difficult one. However, again, it's our position that the judge erred in concluding the seizure was reasonable under these circumstances. There were several alternatives available which should have been explored by the officers, including perhaps leaving the car where it sat legally parked until they received word it was stolen, or giving Mr. Paulo the option of calling someone else to come and retrieve it. And that is the basis of our argument here today.
But that argument depends on us finding clear error in the subsidiary factual finding, right?
Correct. Correct.
And your argument about clear error is that her finding is contradicted by what happened at other hearings.
At hearings prior to the motion to suppress itself.
There's nothing in the motion to suppress transcript that would demonstrate clear error.
We would suggest that there is clear error here, Your Honor. I understand, and that's our argument. Again, some cases are easier than others. And we would rest on our brief as to issue 2.
Can I just ask one question about that,
Yes.
Attorney Lindmark? Am I understanding correctly that the only part of the sufficiency of the evidence that you're challenging is that of constructive possession of the firearm and ammunition?
Yes. We're suggesting there's no direct evidence that Mr. Paulo owned the gun or even the bag that it was found in.
Didn't he admit that he owned the bag that it was found in?
That was something actually that he asked me to bring to your attention, and he's quite right about that. His testimony in volume 2, page 109, he testified that is not my bag per se. On page 24 of my brief, I said that it was his bag, and that was my error.
I understand part of the reason why I'm so confused. You said when you were arguing today that Larkin testified at the dangerousness hearing that he didn't call in the plates until they were at the station. But the representation that's made in footnote 3 of your brief doesn't say that. The representation made in footnote 3 of the brief says, at the dangerousness hearing held pre-trial, he changed that testimony, which suggested came after the motion to suppress, by the way, stating that he, Officer Larkin, called in the car information after Paulo and Rocher were sent to the police station. In other words, while he was still at the park. So I'm totally confused because
it says after he was sent to the police station, not that he was still in the park. It was my understanding that they had left and were en route to the police station.
Yeah, but that doesn't, there's nothing inconsistent with that, right? As long as it's before they decided to inventory the car.
No, our argument is, Your Honor, simply that they decided to inventory the car and took steps toward that prior to any information that the car was.
What's the evidence of that?
Officer Larkin's own statements.
Well, it's not here in footnote 3. I'm sorry. All right. I get it now.
Okay. Any further questions?
No, that's it. Thank you.
Any further questions from the panel?
I interrupted Judge Hand, I think, was asking questions about the sufficiency issues. No?
No, I'm satisfied. Thank you.
Okay. Attorney Sylvia.
Good morning, Your Honors, and may it please the court, Erica Sylvia on behalf of the Commonwealth. With respect to my sister's argument, just a few notes I want to address. It's the Commonwealth's position that the motion judge got it right regarding suppression, regarding both the search of the defendant's person and the inventory search of the vehicle. I believe, in the defendant's brief, they concede that the keys were lawfully seized. With respect to the vehicle, it's the Commonwealth's position that the motion judge got it right based on the evidence that was before her at the motion hearing. Officer Larkin testified, and Officer Pohl of the Raynham Police, she was the individual who obtained the information about the stolen vehicle from Hertz Rental. She testified at the motion hearing, and then also admitted in evidence was a copy of the Taunton Police written inventory procedure. With that evidence, the judge correctly found that, seizure of the vehicle was reasonable in these circumstances. It was, although it was lawfully parked, it was parked in a high crime area.
Well, surely that's not sufficient basis to inventory the vehicle or do anything to it. It's lawfully parked.
Correct. It's not dispositive, but it is relevant here where the vehicle contained, firearm and ammunition within.
It contains firearm and ammunition, and once it's determined to be stolen, sure, they can tow it. But the question that your sister is asking is, what did they know before they decided to search the vehicle?
Sure. So at the point in time, it's Commonwealth's position based on the evidence in the testimony of Officer Larkin that was before the motion judge. Officer Larkin had testified that, upon arriving, the dispatcher had told him, it's a firearms call and an individual is walking to and from a white parked vehicle. He arrives, he sees that white parked vehicle. He testified that there are no other vehicles in that area. And then when he is pat frisking the defendant, and they're sharing conversation, the defendant says, "That's my car over there," or something to that extent. That's when Officer Larkin testifies that he calls in the information. That's when dispatch returns.
No, he didn't testify to that. No, he didn't. Okay. That's what he said at trial. But what he said at the time was someone else called it in, and then he found out about it because it came in over his microphone. Okay. So he literally contradicted himself at trial. And,
yes,
and
but
now your sister is saying he had a different story. He had a different story at the dangerousness hearing. Is she right about that?
I don't believe she's right about that. I do believe, obviously, here the motion judge was not privy to the testimony at the dangerousness hearing or the trial testimony, which had not yet happened. Based on the testimony that was before her alone and what came in, I know Officer Larkin at some point wavers and is unsure whether it was he or his colleague that did call it in, but he maintains that they had called it in during, the frisk and cuffing, and putting the individuals into the back of cruisers. His testimony remains consistent that it was called in during that span of time, still in the park. That's when they receive the information that the car had been reported stolen. And at that point in time, seizure of the vehicle is reasonable. It comports with the Taunton Police written procedure, which strictly authorizes the seizure and inventory of a reported stolen vehicle. And it is the Commonwealth's position that they followed the procedures written therein. They were able to search that car. They were able to search unlocked containers within that car, namely being the backpack. It is also the Commonwealth's position that insofar as, the keys were used at all, they were only used to unlock that vehicle, which was all, lawful in the situation here. With respect to the sufficiency, I just wanted to touch on, obviously the Commonwealth proceeded on a theory of constructive possession. It's our position that, the defendant, it's inferred that he had both knowledge and the ability and intention to exercise dominion and control over the firearm and the ammunition. It can be inferred by the backpack's plainly visible location on the floor of the driver's side of the vehicle, and the holster that was protruding from the open backpack. Based on the fact that the gun was commingled with the defendant's personal affects within that backpack, whether or not the backpack itself was the defendant's per se, it's the Commonwealth's position that where that gun, where that ammunition, where that holster was in the same backpack with prescription medication bottles, credit cards, items all bearing the defendant's name, it's reasonable to infer that those items were his or that he had the knowledge and ability to exercise control over those items. So it's the Commonwealth's position that both the motion judge and the trial judge made correct rulings here, and we would respectfully ask that the court affirm the judgments entered below. If there are no further questions, I'd rest on my brief.
No, there is. I suppose it's a little hypothetical, but let's assume that your sister is correct.
Okay.
That if we had a transcript of the dangerousness hearing, that Lindmark testified at the dangerousness hearing, once we got him to the station, that's when we found out the vehicle was stolen. Anything we could do about that?
Well, does the hypothetical presume that the search happened before or after finding out the knowledge of the stolen
It
vehicle?
presumes the search had already happened and they got him to the station, or the search had already begun. They got him to the station, turns out the vehicle's stolen.
Well, I think, if we knew some more information, then perhaps it could still have been a reasonable inventory search. It's, 1 o'clock in the morning, there's no one to come and, pick up this vehicle. Given our facts.
It's reasonable to inventory a vehicle that's lawfully parked in the street.
Well, that's
without any knowledge other than, I guess, that it's the vehicle of someone you've just arrested. You can inventory.
Well, I would say without more information, no. But here, that's I would say that the evidence before the motion judge was not like this at all.
So, well, I understand, but I'm intrigued by the notion that Mr. Larkin may have completely changed his testimony between the earlier dangerousness hearing and the time that he got the suppression hearing. And it turned out, boy, I just figured out that I better tell them that I knew about that before we searched the car. Well, that would be a little troubling to me.
Well, presumably, the defendant was present for both hearings, and defense counsel was present for both hearings, and that's the cross-examination would be the vehicle to figure that out. And the defendant presented no evidence at the suppression hearing, and it was his right to do so. So it's the Commonwealth's position that, based on what was before the judge, that's all she had to rule on. And I don't think that this court can say, based on what was before her and based on her rulings, that she made a clear error here.
I understand the argument. Okay.
Thank you.
Any further questions?
No.
Okay. Thank you both. The case is submitted and we will resume shortly in courtroom 4.
Thank you very much.
Thank you.